All right, everyone, thanks for joining us at our workshop today to cover public records, sunshine laws, and ethics. And just by way of introductions, we have three speakers today other than myself, Annie Ross. We have Scott Rudisil. He's with Blaylock Walters, and he is the counsel for our IDA. Speaking on sunshine laws is going to be Mr. Andy Cohen from Person Cohen and Mooney. He is the counsel for Districts 2, 4, 5, and 6. And then our ethics conversation will come from Mr. Chris Van Hise with Shoemaker, Loop, and Kendrick, and he is our District 1 counsel. So without further ado, I am recording this and we'll put it on YouTube for those board members that weren't able to make it. Thank you for coming and spending your time with us. And we'll start out with our public records from Mr. Rudisil. Let me get your presentation up.
Thank you, Annie. And first of all, I want to apologize. I had intended to be on camera here today. I just don't know why it's not working. So I'll have to use my radio voice. All right. We're going to be talking about public records today, and I want to thank Andy for letting me take on a new subject this year instead of just using all the materials that I already had prepared. It's good to go back and look at other areas and expand your horizons. So,
glad to help, Scott.
All right. So if we would move it forward, please, Annie.
Okay.
Yep. So we're talking about the Public Records Act today, and if you would go to the next slide. So what is a public record? A public record is any document, paper, letter, map, book, tape, photograph, film, recording, software, or other material, regardless of physical form, characteristic, or means of transmission, that is made or received pursuant to law or ordinance or in connection with the transaction of official business by any agency. So the definition is pretty broad. It's essentially they want any of the information that is reduced to any medium that's part of the transaction of official business to be maintained as a public record. So, all right, next slide. What types of materials are we talking about? Anything intended to perpetuate, communicate, or formalize knowledge is sufficient to be a public record. So obviously this is going to include your typical letters, memos, reports, but also includes computer records and emails, text messages, again, pretty much anything that you can use to communicate is going to be sufficient to be a public record. So generally also includes working drafts or preliminary reports. So it doesn't have to be final in order to be a public record necessarily, but it may exclude your personal notes if those are just notes that you keep for themselves. Although that is an area that is somewhat gray, particularly if you maintain your notes in a file. All right, next slide. I think we got some examples now. All right, sorry, Annie, I think I picked on you on a lot of these, but
That's fine.
Executive director emails her spouse from the office to ask what is for dinner tonight. That is not likely to be a public record because it is not made in connection with the official business of the IDA or one of the districts. So, and this is an important jumping off point just to make a note here. It is the nature of the communication, not necessarily the device that determines whether or not it's a public record. So even though this email came from an IDA computer, an IDA email, doesn't mean that it's necessarily a public record. All right. Next example. Supervisor emails the executive director from a personal email account at home, asks her to put something on the agenda. This, again, Doesn't matter that it comes from a personal email. This is going to be a public record. All right, and then the next one, a neighbor emails a supervisor with comments on the upcoming budget. This email is a public record. And again, this is the same. It doesn't matter if it's an email, if they slipped a note into their mailbox, if they sent them a text, if they did it by Facebook Messenger, however this information is being conveyed, it is a public record. Unless, of course, it is being conveyed orally, in which case there's no record to maintain. Just something to keep in mind. All right. Next slide. Staff member decides to tape record their staff meeting. The tape is likely a public record. So, typically there's not a requirement to tape meetings, but once you start doing that, that is likely a public record. All right, next slide. This is one that comes up quite a bit. I know this is one that has come up quite a bit at Town Hall there. Private entities. And when are private entities, or the records of private entities, subject to the Public Records Act? And the answer to that is when they're acting on behalf of a public agency. Okay, and so that can arise in different manners, depending on the type of private entity that we're talking about. If the entity is performing a government function, then that is going to be an automatic. If they're performing some kind of function, thinking about privatization of different areas of the government, if that's what the private entity is doing, then that entity is going to be subject to the public records laws to the extent that they're performing that function on behalf of an agency. There are some other scenarios that aren't quite as clear as that. I'll give you an example. You see this a lot of times with different types of entities that may be in like a not-for-profit arena. If they are, say, maybe leasing land from a local government and they're perhaps getting some kind of funding from a local government, at some point there may be questions asked as to whether those types of entities are subject to the Public Records Act. And in those scenarios, what the courts have done is they've kind of looked at a totality of the factors to determine if the entity is acting on behalf of a public agency. And they look at, where are they getting their money? How much of their money is coming from, a particular local government? Are they commingling funds with the local government? Or are they created by a local government? Do they have, members of the local government body serving on the board, meeting in the sunshine? I mean, I'm joking, but at the same time, how are people able to access this workshop if they weren't on the original?
Well, it's
Zoom?
we have it on our website, so if any, being a public meeting, we include it, typically we include it in our advertisement that goes in the newspaper.
No,
And we
but
have a,
what I think Scott's saying is, how does the public able to access what we're doing right now?
Correct.
oh, this one. Oh,
Yeah.
yes. Well, I'm going to be videoing it and can put it up on YouTube.
We're not taking any action, so we could just treat it as a workshop, but
No, hey, this is Pete Bocage. This raises a big issue for me, though, is when we have our CDD district meetings, while the supervisors may choose to be present in the meeting room, we open it up to Zoom for our public. So that means we now have, unfortunately, potential exposure for a similar type situation at any of our district meetings.
Exactly.
Yeah,
It seems to me we've got to give some thought on how we might be able to manage this.
This is Alan Roth, and Zoom is notoriously not secure.
No kidding.
It's always been a problem with it.
Yeah,
Well, we
luckily this is the first time we've had an issue. We can look at other ways of doing Microsoft Teams or something like that. We might need to move to something different.
We use GoToWebinar with our genealogy society, and the whole state uses it, all the genealogical societies, and it's been excellent, you know.
Scott and Chris, are you guys comfortable moving forward since we haven't really advertised this? I mean, we're not taking any formal action, but I don't know what your thoughts are.
Yeah, I mean, I guess my thought would be we generally advertise these as workshops, but I think we do that kind of in an abundance of caution, because really, as long as we're sticking to the general topics that we're talking about today and not getting into specifics related to our agencies, then I think we're probably all right.
And I concur with that. I don't think we run afoul with the sunshine. Annie, is town hall open if somebody wanted to drive over this afternoon pursuant to the previously published notice? Could they walk in and perhaps be able to view what is transpiring?
Yes, we'd be able to accommodate them.
Okay, I feel comfortable going forward.
Okay, I'm fine.
All right, so do we have most of the people back on now?
We're missing-
This is Marie. I'm on the line. I'm taking roll of who's here now, and I also took roll of who was here on the first call.
Okay.
So I'm gonna mute myself and excuse myself from the meeting for just a little bit to give everybody that's not on this call a courtesy phone call to let them know that we have a new meeting.
Before we continue again, this is Alan Roth again. Is there anything we can or should do about reporting this incident? I'm sure Manatee County has some sort of cyber crime person.
It came up briefly and asked me if I wanted to, report it to Zoom. I went ahead and did that, but I don't know that the county would do anything with it being an internet.
I'd love to be able to catch the guy or person, assuming it was a guy.
Okay, so do we want to continue?
Yes.
Okay.
Go ahead and continue.
All right. So I think this is where we left off. This is what happens when how do private entities become subject to the Public Records Act, and the example here is CDD hiring a private engineering firm to serve as the district engineer, and this goes back to the government function piece. So that firm is going to be subject to the Public Records Act to the extent that they're serving in that role, which is similar to the manner in which it applies to Andy and Chris and I. So, all right, next page, websites, blogs, Twitter, Facebook, internet. Obviously, this is an area that is constantly evolving now. I'm not aware of any good case law on this at this point, but I think, the safest course generally is to try to avoid communications and conducting district business on these types of forums. However, if the goal is transparency, this is a great medium for people to get out information to the public. So a lot of local government agencies are heavily using these types of fora for their to conduct their business. So I think these types of issues generally I think are kind of a case-by-case basis. I don't know if we have adopted policies. I know we did several years ago as to how supervisors should conduct themselves with respect to public records and emails and texts and things like that. I think different agencies tend to take different approaches when it comes to these things, but you know, one good rule is to, if you're gonna engage in something like this on there, particularly if you're getting into topics that are controversial or that are related to the work of the district, it's probably a good idea to take a screenshot of whatever you put out there and just go ahead and send it to the clerk of your agency to keep a record of it. All right, next. Attorney-client records. This is one that surprises a lot of local government board members when they join the board and they think that they can shoot emails back and forth with their counsel, and that those would be privileged. And the answer is that they generally are not. So when you're communicating with your local government attorney, there is no privilege for those communications. However, there is an exemption, which is smaller, and it is related to when you're preparing for litigation or adversarial proceeding, or you are in litigation or adversarial proceedings, and that is limited to the attorney's work product, or if the attorney specifically asks a board member or staff member to prepare some type of document related to the litigation. All
I
right.
have a question on that one.
Sure.
So say you're handling a matter for CDD
Mm-hmm.
and there's also them that filed a complaint and an answer, and now we're in discovery. And you call me on the phone and ask me, Jerry, what about, I have discovery and this question is this, do you have, can you give me what our answer, or what do you know about this? Is that that's not protected at all?
Yes, that would come under the exemption for records that are prepared at the direction of the board attorney. So
Yeah, I agree. I just wanted to make sure, or something like that. Yeah.
yeah,
So if we're discussing a actual lawsuit, not prospective, and it's dealing with that lawsuit, then it's generally protected.
well, like I said, it has to be at the direction of the attorney. So if you're just volunteering stuff,
But I'll wait on the call from you then, is what you're telling me.
yes, more likely an email setting it up so that there's a record that the attorney requested it.
Okay, fair enough. Thank you.
Mm-hmm. All right, next page. We have an example here. All right, you email district attorney, tell them that you just attended a seminar on sunshine law that got cyber hacked, and now you don't know what to do. You've been talking to other board members outside the sunshine. You've been destroying public records, and you are the second gunman on the grassy knoll. So this is going to be an email that will be a public record. And that will be you after you finish your round.
I don't have that much hair.
All right. Inspection copies. All public records of a public agency must be made available for inspection and copying upon request within a reasonable time. So generally folks have the option. They can either come in and inspect, or they can ask for records if they are willing to pay for them at the promulgated rates. All right, next page. This is a list. There are exemptions all over the Florida statutes for public records. And so this is just kind of a handful that I picked out that, that are applicable on a regular basis in the local government context, but there are a ton more. And so that's why whenever issues come up, we have to go through and do a thorough review to see if there are any applicable exemptions. All right, next slide. Department of State has adopted a general records schedule for state and local government agencies. And so this is the document that tells our staff how long they have to keep which types of records. So, and it can vary a lot depending on what we're talking about. So the example I gave there is that minutes of a regular meeting must be kept permanently, but video or tape recordings of a meeting only have to be kept for 2 years. All right, next slide, penalties. Yep. This is a supervisor down in Fort Myers right here. So it is somewhat of a joke, but technically penalties for violating the Public Records Act do range from $500 fine up to third-degree felony, depending on the circumstances. There are what is more common in terms of penalties is the attorney's fees provisions, which kick in certain cases if a member of the public is forced to bring suit to obtain a public record. And I think that is it. Open for questions, or we can save them all till after the others.
Scott, this is Alan. Can you hear me?
Yes, I can hear you, Alan.
If this is a long answer, then we can defer it to another time. But generally, I have to admit, I took a little while to log back in, and I missed a little bit at the start. So you may have answered this, and I apologize. But I assume your comments relate to CDDs and the IDA. But to what extent are HOAs subject, the homeowners association subject to the public record regulations?
Okay, so we had, there was a slide about midway through that talked about when private entities can become subject to the Public Records Act. And generally that occurs when they are acting on behalf of a public agency.
So
Okay?
is an HOA a public agency?
No. That's why I went to this section. An HOA, it would be considered a private entity.
Okay.
Okay. So records of a private entity generally are not subject to the Public Records Act unless that entity is acting on behalf of a public agency.
All right.
And there are different factors there. Now, getting to your question, when it, at least here locally, and how do the HOAs become subject potentially in our circumstance, that is because they are essentially voluntarily providing their records to a government agency, and that agency is receiving them in the course of their official business. And so that's what would at least arguably render those a public record.
So the fact that they're physically stored on the town hall servers creates the kind of the public, brings in the public record statutes.
Typically, it is more related to the nature of the record and not where it is stored. But that can become a factor. I think it has to do more with the receipt of the records by the local government, which is receiving them as part of a management function.
So if town hall receives information relative to HOA receivables, something totally clearly related to an HOA activity, but it's a town hall employee performing a HOA task, and that town hall employee sometimes works for the CDDs. Is that information a public record?
Well, again, and we've talked about this obviously before. This is an area that is not entirely clear, and largely because the the local government acting as a management entity for a private company is not a normal circumstance.
Okay,
So, but,
so there's
but
not a lot
that's
of case law.
right. I'm not aware of any, to be honest. But that's where it would come in. If you go back to the original definition that we talked about for public record, and that is that it is a record that is created or received by a local government in the transaction of the official business.
Okay. That actually helps. Thank you. Thank you.
Mhm.
Probably argue both sides too.
Yeah. Yes, I think there's definitely arguments that could be made the other way.
Okay, any other questions for Scott?
Yeah.
Nope.
Okay, then I think we move on to Mr. Cohen.
Yes, good afternoon, everybody. And thank you, Scott, for letting me do sunshine this time. Well, here's a picture of me, since I haven't seen many of you in almost 9 months, in case you forgot what I look like. Today, yes, I'll be dealing with the Sunshine Law. And really, the idea behind the Sunshine Law is that as much of a stumbling block as I know some board members feel that it is, the general idea is to prevent what used to be these sort of smoke-filled backroom deals, and that we want to make sure that everything is out in the open for not only the residents of our respective CDDs, but of course, the residents across the state. So next slide, please. The Sunshine Law is based on, well, it has two bases. One is with regards to, you can find it in the Florida Constitution at Article 1, Section 24B, as well as in statutory law at Section 286.011. And next slide, please. Something that seems to be complicated in that it trips up a lot of people really is quite simple in that there are 3 elements to the Sunshine Law. The first is that meetings of the public boards or commissions must be open to the public. That means what it says, that it can't be in private. We have to have our meetings out in the open. We have to have them at a publicly accessible facility. In fact, there are Attorney General opinions out there where someone said, hey, what if I have it in my home, but I advertise it, I invite everybody, I make it, fairly widely known. And the Attorney General says, no, that's sort of a chilling effect. We want to make sure that people feel encouraged and comfortable coming to the meeting. Second is the reasonable notice of such meetings must be given. What that means for CDD world is that we need 7 days notice in the newspaper. While it's helpful to put it on our bulletin board or on our website, to send out an email to residents, what's required is that you have 7 days in the paper. And then the third and final element is that minutes of the meeting must be taken. So those minutes can be skeletal. There's really no set template for those. It's sort of up to the respective boards, as long as you capture the action that took place during that time frame. So I'll go through each one of those in a little bit more detail now. Next slide, please. So meetings of the public boards or commissions must be open to the public. Let's talk a little bit more about that. A meeting is defined as all discussions and deliberations by 2 or more members of the same board, whether formal or casual, relating to a topic that is pending before the board or foreseeable to come before the board. What's important here is that those of you who might have some experience with HOAs, it's a little bit different in that with an HOA, a quorum of that board couldn't get together. So if you had a 5-member HOA board, 2 members could, but 3 couldn't. For us, no more than 1 member. You cannot get together with any of your fellow members to discuss CDD business. And next slide, please. What is a meeting? It's more than just your classic you know, sit down at the table in town hall to talk about CDD stuff. It encompasses emails. That's the thing that trips everybody up. Telephone conversations, social media, which Scott talked a little bit about before, text messages. You cannot email, you cannot engage in a conversation with your fellow board members. So while you should not be emailing your fellow board members, you might have heard me say in the past, and those of you who remember, that you can send out an email that says, hey, everybody, don't respond to me, but we're going to, these are my views on the pond remediation that we're going to talk about at the meeting on Thursday. As long as nobody responds, you haven't engaged in a conversation, so it's not technically a sunshine violation, but I discourage that because it's very easy for someone to respond, thank you, talk to you Thursday. Then all of a sudden you've got a violation. So it's best just to stay away from that in total. It's best, I advise my clients not to use social media. I know Scott talked about it and how it can be a useful medium, but it creates all sorts of issues. It's very easy to put something out there and then have a fellow board member comment, have a potential sunshine problem, not to mention the public records issues that Scott alluded to. You know, when you use your CDD email address to send something to a neighbor, let's say, town hall is going to have a record of that. But guess what? When you've sent something on Facebook and we get a public records request for everything you've ever said about ponds over the last week, I'm going to have a hard time getting a hold of that record. So I encourage my board members not to use social media for CDD business. The final bullet point there is that communications relayed through an individual acting as a conduit between board members is not allowed. So you two board members on CDD5, Dave, you can't tell Annie, hey, tell Alan X, and Alan can't tell Annie, well, tell Dave he's full of it, it's really Y. That's a conversation. You've simply used Annie as the conduit, so that's a no-no. Next slide. Meetings can occur anywhere. So that just reiterates what we said. It's not just the classic sit down. It's emails, it's text messages, things along those lines. You're allowed to still have friends, but you need to be very careful about corresponding with your fellow board members outside a duly scheduled meeting. Next slide. This is just one idiosyncrasy I wanted to point out, which is, since we just went through an election, for instance, in CDD5, I'll pick on CDD5 today. Mr. Peters became the supervisor-elect when Ms. Robertson pulled out of the race. So as a supervisor-elect, you are actually subject to the Sunshine Law in that you cannot correspond with your fellow board members that you will be serving with. Mr. Peters would have been able to talk to Ms. Robertson about anything related to the district because they would never be on the same board together. But he couldn't call up Alan and say, hey, fill me in on what's going on because I want to get up to speed. Next, please.
Andy, I have a question. So that means, say I decide not to run for re-election, and then somebody wins in my seat and I can't communicate with them. Is that correct? Or limitations?
You can communicate. Let's say you do not re-up for election and someone else gets voted to take over your seat. On your way out, Jerry, you're never going to serve on the same board with that person. So you would be able to sit down with them and relay whatever knowledge base you had, you know, whether it was runaway or whatever you wanted.
Okay.
Andy, I got a question. This is Alan Roth.
Yes.
If I have an issue I want to bring up at a say a future budget workshop, and I call Steve, tell him I'd like to see this on the agenda for the next meeting, and that I think it'd be worthwhile if my other fellow supervisors were forewarned. Can I ask him to forward, to tell them that this issue will be discussed, as long as he doesn't say I was the one who brought it up?
You can. Actually, you would even be able to, like I said before, you could write to your fellow board members and say, I want to discuss palm trees at our budget workshop next week. Don't respond to me. It's not my favorite thing to do, like I said, because it's very easy for them to respond, but you would be able to do that. So carrying it one step further out, using your example, Alan, where you talk to Steve and you say, hey, Steve, just make sure that all the board members know this is going to be on the agenda. That's okay. You're not conveying any sort of conversation or using him as a conduit, as a go-between up and back. You're just pushing that information out.
Thank you.
Sure. And this sort of segues into the next slide, which is what about meetings with staff? The general rule is that you can meet with staff individually. You can sit down with Annie, talk about CDD business, Steve, myself, Paul, and you're typically allowed to meet with staff unless they have somehow put on, which happens sometimes, a different hat. If they're all part of some committee that you're also serving on, well, then you might be triggering some potential sunshine issues. But the classic example of, like Alan said, he just wants to sit down and talk with Steve about some budget issues, not a problem. No sunshine issues triggered there. Next slide. One of the things that I just alluded to was what about meeting with the attorney? Next slide. Typically, meetings with the attorney are open. They are subject to the Sunshine Law. There are some very limited exceptions. One has to do with collective bargaining, never comes into play with CDDs. The other is something called a shade meeting, which is an attorney-client session where the board can meet with the attorney outside the sunshine, but you need to have pending litigation. So I get asked this a lot. Threatened litigation doesn't work. If somebody has tripped and fallen in CDD2 and they say, give me $1 million or I'm going to sue you. Can the board sit down and try and, say, well, maybe we can give them less or talk about it? No, not outside the sunshine. But once you're sued, then you can sit with the attorney to talk about two limited things. One is strategy related to litigation expenditures, and the other is settlement negotiations. And in those cases, there's a whole host of rules that apply. There's a script that needs to be followed, there's special notice, and there's court reporter present, taking down everything that's said. And then when the case is over, that transcript will become public. Now, individually, you could talk with the attorney at any time. It's just when you as a board want to sit down and talk with the attorney. As Scott talked about before, sometimes you have to be careful about what's public record and what isn't between you and your attorney. But it's not a sunshine violation to individually sit and speak with him or her. Okay, next slide. So what is open to the public? Well, we talked a little bit about that before. The facilities need to be accessible. The second bullet point is a good one. You can't have inaudible discussions. So you need to be mindful when you're sitting up there at the table, when we actually have a table and people back in the room. You can't be whispering to your fellow board members about CDD business because the public is entitled to hear what's being said. And truthfully, you shouldn't be doing it at all, because even if you're whispering about the golf game in the morning, they're going to be going, oh, they're talking about how they're going to vote on this next issue or whatever. So that brings up something else I want to say, which is appearances matter. You do need to be mindful that, even if you and a fellow board member are standing by the pond talking only about the Super Bowl, someone's going to drive by and say, hey, they were talking about the water quality test of Lake Eline, which is going to be on the agenda tomorrow. So you need to keep in mind that appearances do matter. The public has a right to view the meeting and hear all discussions. Next slide. So what does that mean? Another part of open to the public is the public's right to speak. So everyone needs to be provided a reasonable opportunity to be heard on a matter that you're going to take official action on. And that is why we do audience comments at the beginning, because that way everyone has their opportunity to speak on things that you're going to potentially take action on your agenda. You may have heard me or your other counsel take a break in the past when you start to vote on something that might not have been on the agenda. You're allowed to do that. You're allowed to go off the agenda. But if you do, and you're about to take action on something, then you need to take a break and open it up to the general public to see if they have any comments on that, because they didn't have their opportunity before.
Andy, I got a question on this. If somebody comes up and say, I didn't have the opportunity to comment, I was on a Zoom meeting, let's say that, you know, it creates issues with this. What's a remedy for if they file a complaint about that matter?
Well, it kind of course, is fact specific as to what the issue was and what action took place. But you do, with sunshine violations, if one truly occurred, you do potentially have the opportunity to go back sometimes and, quote, remediate or repair the action that was taken.
So what does that mean in plain English to me?
That means if you took a vote and they really didn't have the opportunity to provide input on it, you can put it on another agenda, give them the opportunity, go back and vote again.
Okay, thank you.
Sure. Next slide. So while the public has the right to speak, it is not unfettered. So they can't be disruptive, they can't be obscene, things along those lines, and we can put limits on their public comment, which we do. Typically, most of my boards allow the members of the public 3 minutes to speak. And, you know, we usually err on the side of caution. If they're finishing up, we're going to give them an extra 30 seconds or something along those lines. But they don't get to stand up there for an hour and interrupt your meeting. And then the last point, when there is a public hearing, then they usually get 2 bites at the apple because they have public comment. Then they have an opportunity during a public hearing to provide input on whatever that issue is. And it's usually a little bit more time that they're allowed. Next slide. This just reiterates some of the things that I just went over with regards to adopting rules related to orderly conduct and structuring the agendas in a way, like we said, to allow for meaningful comment. Okay, so that was the first element. The next element is reasonable notice of such meetings must be given. As we said, in CDD world, that equates to 7 days in the paper. That's Florida Statute 189.015. You have to do that unless there's some limited examples, like for a bona fide emergency, health, safety, welfare. We have some rules with regards to that, but it's pretty rare. Next slide. So, and I talked about this before, is that it doesn't prevent us from adding items to an agenda after publication, but if we do, then we need to reopen it up again. Next slide. The final element is that minutes of the meetings must be taken. So as I said at the very opening of this, there's no, you know, perfect meeting minutes template out there. If there was, I'm sure Marie would have created it, but it basically your minutes can be skeletal. They do not need to be verbatim unless you want them to be. If you should happen to tape your meeting, which you're not required to, but if you do, it would be a public record. Next slide, please. We already covered that, so the next one again. Magical minutes do not exist, like we said. I did want to add just one slide to talk about the virtual meetings because it's probably still on everybody's radar. We're doing this virtually, but back at the beginning of the COVID pandemic in March, the Attorney General issued an advisory opinion that the governor may lawfully suspend the physical quorum requirements for local government meetings. So the way it's always been historically is that you need a physical quorum of your board seated in the room to have a meeting. So for us, that's 3 people in the room. The Attorney General, and then followed by the Governor's Executive Order 2069, suspended that physical quorum requirement. That was extended a number of times until November when it finally expired. So what that means now is that we have to put 3 board members in the room, but 1 or 2 of the others are allowed to appear virtually. We have the board vote on that at the beginning of the meeting. And then staff is always allowed to appear virtually if that's an option that the board wants to make available.
Well, excuse me, this is Preston. What about this meeting right now? I'm on CDD1. we've got 3 of our board members listening in on this meeting.
With this particular meet, thank you for asking that. What that has to do with the quorum requirement is for taking official action. And we are not going to be taking any action here today. We are treating this as a workshop. And because there's no action being taken, we do not need to have a physical quorum present.
But that flies in the face of the appearances are important.
Excuse me?
To me, that flies in the face of the issue of appearances are important, is what you're saying. Before you said 2 board members could be standing by Lake Eline talking about the Super Bowl. Somebody sees that and they could say, hey, they're talking about the Eline Lake's going to be something tomorrow. They have no idea what I'm talking about, but appearances are important. I understand that. So how is this not appearance? How does the concept of appearances are important not apply in this case? We're just talking about the Super Bowl earlier.
It does apply. Appearances are important, like we said. And even though this is not required to be have people present in the room because we're not taking official action and we're treating it as a workshop, we did advertise it. And so we did put the Zoom information out there. That of course didn't go so well since we got hacked with it. You might not have been there, but at the very beginning of this new Zoom, we meaning staff as well as CDD1 Council and IDA Council and myself were discussing whether to move forward or not, since we did not have the public knowing this new Zoom information. But we did decide to proceed since no official action was going to be taken. But to your point of repeating what I had said about appearances matter, that is why even when we have workshops, we still put ads out there in the newspaper to have the public have the opportunity to be able to participate should they so choose.
Andy, this is Alan. As a partial follow-up, can't we cure breaches by kind of referencing what might be an inappropriate conversation at the next scheduled conversation?
Potentially you can. If you feel that there is something that may have been amiss, I'd encourage you to speak with whomever your counsel is for that board so that they can advise you on the best way to try and move forward. Because it can be very fact specific.
Once again, question along those same lines, we seem to always err on the side of appearances are important and very cautious. I know that I was for years on the HOA board, and simultaneously I was on the CDD board. That's occurred to 2 or 3 of us and exists in a situation right now. We have committees on the HOA which see CDD members on this board, on the CDD1 anyway, show up at a meeting of the HOA committee meeting on an issue that has nothing to do with the CDDs. And we've always been at loss as whether that's allowed or not, because appearances are important. And we've got 2 members of the board sitting on a committee of the HOA, even though they're not discussing anything with the CDD.
Right. And, you know, from a pure legal standpoint, that's allowed. But you'll also hear Annie say frequently, and myself, and I'm sure other attorneys, if 2 CDD board members are going to show up at a public meeting, let's just say Manatee County Commission meeting that has to do with Lakewood Ranch information, it's best that they sit there with their hands folded and not engage in any discussion. If someone is going to talk, it's best to just have one person. Now, you're still residents, and I understand that you still want to have the ability to advocate for your community, but we need to be sensitive to these issues.
Thank you.
Andy, I go to the county commission a good bit.
Yes.
And it's okay if I show up as a private citizen, but not representing CDD2, right?
Well, yes, but you still, even still, if you know, Mike Finney is there as well, and it's a CDD issue that's going to come up, it's best that either neither of you speak or only one, because you don't want to get into a back and forth with Mike about that CDD issue during that commission meeting.
Okay. All right.
Going back to the slides, with regards to the virtual meetings, all sunshine, should we ever get back to doing them again, all sunshine law requirements still apply. We have to notice them. They're open to the public. Minutes are taken. Next slide. What are the penalties if we screw up? Well, there are criminal penalties, there are civil fines, and then what I always say is the most important, what I call the most important one, they're all important, is that in a civil action, someone can recover attorney's fees. And we all read the papers and we know that sort of a cottage industry has sprung up, especially in our geographical area, where people sue for sunshine violations. And next slide, please. In 2009, the city of Venice lost a case where there was a judgment against them of over $777,000. When you factored in the attorney's fees that they spent on their end as well, it cost them over $2 million. Next case, next slide. Citizens for Sunshine versus Susan Chapman. That's another local one with the city of Sarasota in 2018. In that particular case, the city was successful, but it cost them $400,000 to get there. So, you know, you can decide whether they were successful or not. The point of that all is that we need to be sensitive of these issues. Next slide, please. Every one of you board members took an oath of office, and it says what it says there, that you solemnly swear or affirm that you will support, protect, and defend the Constitution and government of the United States and state of Florida, that you're duly qualified to hold office under the Constitution, and that you will well and faithfully perform the duties of your office on which you are now about to enter. So you took an oath. Obviously, that should be enough. There's criminal sanctions, there's fines, that should also be enough. But if it isn't, keep in mind that you do not want to cost Lakewood Ranch and your fellow residents a huge judgment and attorney's fees of potentially millions. So these are important issues, and I would encourage you that whenever you have any questions, you have amazing staff. Talk with Annie and her team, talk with your attorney. Everybody's there to try and help everyone navigate through this. I'm glad to answer any other questions.
Good job.
Thank you.
I wanted to just pipe in. Can you guys hear me? I know Marie was saying I'm kind of small volume. One of the things that we as staff notice occasionally is what I would call the parking lot discussion. We'll be going up to our offices after the meeting's over, and we'll see a couple of the board members talking. Now, you could be talking about the Super Bowl and all that good stuff, but just that appearances piece, especially in the parking lot right after a meeting, can be taken very easily that you're discussing something that just happened in the meeting. So just keep that in mind as you're heading out to your car and want to talk with everybody. Maybe wait till if it's about your golf game or about whatever, you know, wait till a little bit later at a different time or something, because it does look pretty suspicious right after a meeting.
Annie, this is Preston. I have problems with that because an accuser has to have some basis in fact of accusing me of talking about business when he or she has no clue what I'm talking about.
Well, but they could still accuse you, file a lawsuit, and we could win, and it would cost us a bunch of money to win. So it's best to not even be in that situation.
I can give you an example out at Longboat Key when I was there. One of the other commissioners leaned over to the mayor and said something to him at the meeting, and it was watched by the local attorney that keeps track of these types of things. And we got a letter the next day that they wanted to know record of what that person had said to the mayor. And in this case, it ended up he was asking for a bathroom break because it had been quite a while since they've had taken a 5-minute break. So we were able to, by virtue of the mayor then saying, well, it's time for a break, you know, kind of prove that. But it's those things can, they jump on them when they occur.
Annie, I agree with you. In light of a couple of individuals in Manatee County, we got to be very cautious.
Yes.
Now, I think on our agenda, we have, let's see, Mr. Van Heis.
Thank you.
Anything on your, let me
And
see
you
if I can get,
can move ahead. Yep, that's the cover page. You can go ahead to the next page. And thank you, Annie and Marie, for putting all this together. And I commend Scott and Andy for their remarks, all very instructive. I'm going to talk about ethics for public officials, local officials, which all supervisors are considered local officials as a matter of the Florida Code of Ethics. So you see on my first slide, it's I asked the not so rhetorical question as to who said this, and I quote, "A public office is a public trust. The people shall have the right to secure and sustain that trust against abuse. To ensure this right, there must be ethics in government." I give all these choices down here and you don't have to answer out loud. I'll tell you who said it and we can go to the next slide. It was your fellow citizens, the people of the state of Florida, who the initiative started in the late 1960s. And by 1976, an amendment to Florida's Constitution was passed by the citizens of Florida and codified in the Constitution at Article 2, Section 8. Just by way of a little bit of history, Florida, in case you don't know, has long been a leader among the 50 states in creating and establishing a paradigm for ethical standards for public officials. So, because in Florida, I guess, the citizens have, through this initiative, wanted to enhance and protect the public trust in our government. So in 1976, the Florida Constitution was amended to provide this new set of constitutional guarantees concerning ethics in government. The ethics in government, as codified in the Constitution and by statute, creates an enforcement mechanism through an independent commission, which is called the Commission on Ethics. That commission investigates complaints concerning breaches of the public trust. And that's really what is of paramount importance under the Code of Ethics. It is to ensure and guarantee the public trust in our government officials. There's no criminal penalties for violating the Code of Ethics, but there are various measures of sanction, including administrative fines, removal from office, reduction in salary for violations of the Code of Ethics. The Commission on Ethics maintains a very comprehensive website. If an ethical issue pops up over the course of your regular service on the board, you have the ability, first and foremost, you can call the board counsel with a question, but the Ethics Commission, you can just type into Google Florida Commission on Ethics and the website will come right up. The website is www.ethics.state.fl.us. At the next slide, this is kind of a snapshot of some of the key components of Article 2, Section 8 of the Florida Constitution, which again is that section of the Constitution where the Code of Ethics was first created through the action of the citizens of Florida. I've just quoted subsections of that component of the Constitution, and I just stress for your consideration that the ethics laws in Florida primarily focus on public disclosure to ensure the public trust. And you can go to the next slide. And this is just where you find what was initially adopted in the Constitution, then codified into law. It's called the Code of Ethics for Public Officers and Employees. It's in the Florida statutes, chapter 112, 311 through 112, 3261. And in the next slide there, that's primarily what I want to talk about, is the two major categories that the Florida Code of Ethics for Public Officials falls into. The first is prohibitions, things that public officials cannot do. The second is required disclosures, disclosures required by Florida law if you are a public official, or to really put a fine point on it, supervisors of special districts are local officers, which is a defined term in the Code of Ethics. So all supervisors of all of the districts in Lakewood Ranch are by definition local officers. So here's some prohibitions. Going to the next slide. Gifts. And you see at the bottom of the slide where it says 112.313 sub 4, that is a reference specifically to that subsection of the Code of Ethics from where I'm quoting the language above. But as a general matter, local officers, public officers, shall not solicit or accept anything of value. And there's a whole litany of things to describe things of value. And I stress, not only is what is described in the statute, which you see in front of you, the prohibition on accepting anything of value, there is a section in the Florida Administrative Code that further describes what things of value are, and that's section 34-13 of the Florida Administrative Code. Just kind of going further into what things of value are, I have some examples on the next slide. And you can see here, gifts can include the use of property, a less than market rate loan, tickets to an event, transportation, lodging, food, or beverages. And again, the statute sets forth that you cannot solicit these things with an understanding that official action that you would provide in your role as a local official, that your decision-making function, if you will, would be influenced if you received any of those things of value. You cannot accept any compensation, payment, or thing of value if you know, or as the statute says, with the exercise of reasonable care, you should know that it was given to influence an official action on something that you're going to do in your role as a member of the Board of Supervisors. The next prohibition identified in the Code of Ethics is improper influence. And again, these are quotes from the statutes. Public officers, and again, that's a defined term of which all of you fall under, are prohibited from corruptly using or attempting to use their official position, property, or resource within trust to obtain a special privilege for themselves or for others. And then there's a definition of what corruptly means, and it's spelled out here. If a public official is deemed to have acted corruptly, they must have acted with notice that their conduct was inconsistent with the proper performance of your public duties, and that the action would inherently be a violation of the Code of Ethics. Next prohibition under the Code of Ethics is a prohibited use of information that you obtain in your role as a local official. And again, this is right from the statute, current and former, and that's important. If you leave the board and go back into private life, there is a prohibition from disclosing or using information that is not generally available. The information is not generally available to members of the public, and you obtain that information as a result of your position on the board if you use that information for your own personal benefit or for the personal benefit of others. So you have to be careful and protect information that you've learned in your role as a supervisor, that you don't use it while you're still a supervisor for your personal gain, or after you leave your position, you use that information somehow for your personal gain. Next slide, please. Nepotism, very broad definition in the Code of Ethics of what the nepotism prohibition involves. And you can see here, there's a general prohibition from the appointment, promotion, or advancement of relatives that are employed through the district. And again, the definition is pretty long. It seems like anybody you've ever had as a quote unquote kin folk would likely fall under the nepotism prohibition defined in the Code of Ethics. Next slide. Next prohibition is the conduct of business with your district. Just as a general matter, whatever your private business is, there's a general prohibition on your personal business, your employer doing business with the district. There's exceptions and there's provisions if you work for a company that's going to submit a competitive bid during a solicitation of bids for services. But as a general matter, as a local official, a member of the Board of Supervisors, you are prohibited under the Code of Ethics from engaging in business relationships with the district. Next slide. And this is really kind of part and parcel to the last slide, but public officers, local officials are prohibited from holding employment or engaging in a contract with a business entity or agency that is regulated by, or more in this realm, actually doing business with the district for which you sit on the Board of Supervisors. The next aspect of prohibitions, prohibited conduct under the Florida Code of Ethics is voting conflicts. So as a supervisor, you are prohibited under the Code of Ethics from voting or participating in a matter which would benefit your private interests. And so there's a discussion or a description in the code as to what your private interests would be. And I've summarized them with these bullet points. It's any matter that would inure to your private gain or loss, and under the statute in which you knew would inure to your private special gain or loss at the time you were about to take the action, which would inure to the special gain or loss of a company that you're employed by. That again goes back to the other prohibitions about doing business with the district, or which would inure to the special private gain or loss of a relative or a business associate that you have a relationship with. If you come into the circumstances, we can go to the next slide, where a voting conflict is known, you are required under the Ethics Code to announce that the matter may be a conflict of interest, and you must abstain from voting on that matter. And after, you need to submit what's called a memorandum of voting conflict, which is a form document, and it needs to be provided to the secretary of the board, just to memorialize that the conflict of interest was known, was announced, and that you had abstained from voting on the matter. If you don't recognize that you may have a conflict until the matter comes before the board, you are permitted after the fact to make a disclosure at the first meeting that you recognize that you walked into a voting conflict. The very first time you have the opportunity at a regular meeting to disclose that, you are obligated to under the Code of Ethics, and the same thing has to happen. You have to not only disclose it, you have to fill out the memorandum of voting conflict that is submitted to the board clerk to be maintained in the record. That after the fact disclosure, if that occurs, you have 15 days after making the disclosure at the next meeting to fill out the form and get it into the clerk's record. So that's kind of a quick but pretty fine point of these very specific prohibited items of conduct that are specified in the Code of Ethics. So besides prohibitions, we have disclosures. And as a local official, you do have obligations to make certain disclosures, financial disclosures, as a consequence of your role as serving as a public official. So the first disclosure requirement is what's called a statement of financial interest. It's called the Form 1 with the Commission on Ethics. And you have an annual obligation to file the Form 1, and you have your first obligation to file it within, let me double check my cheat sheet. Your Form 1 needs to be filed within 30 days of your appointment to your office, and then annually you file by July 1st of the following year. So for 2020, to the extent you haven't filed your Form 1, you have until July 1st of 2021 to file that form. And there's a sample of the Form 1 in the materials here. There's besides the Form 1, as you can see in the summary here, there's also a Form 1F, which is the financial disclosure form that the statute requires you to file within 60 days after leaving office. I have an example of that form in the materials as well. And then there's a gift disclosure that is required to be filed quarterly if you have any gifts to report that are in excess of $100 in value. Excuse me, you can go to the next slide. So some of the basic points about the disclosures. The financial disclosures make you disclose the sources of income and assets and also disclose liabilities. You do not have to disclose specific dollar amounts in these disclosures. Like, for instance, I work at the local Chick-fil-A and my salary is $25,000 annually. You don't have to put the number in. You just have to disclose that it's a source of income. And what the form contemplates is identifying a percentage of where your sources of income come from. If you work at Chick-fil-A and that's 50% of your income, and the other 50% of your income comes from rental property that you own, you would list them both. But again, you don't have to put the specific dollar amount. You can go to the next slide. This is just kind of a nutshell on why the financial disclosure submittals are important. It gives you an annual reminder about areas that could create a conflict in your role as a local official. It also provides citizens with a way to monitor potential conflicts of interest. Possibly it serves as a deterrent to public officials from considering engaging in activity that could result in a conflict. But primarily, and it goes to the underlying linchpin reason that the citizens of Florida adopted a code of ethics is to instill confidence and public trust in their government officials. The next form is just a real short bullet point of what goes in the Form 1. The next slide after that is an example of what the Form 1 actually looks like. There's not a 2021. You can see that this one says at the top 2020. There's not a 2021 version of the form yet because we haven't reached the filing deadline for 2020, which again is July 1st of this year. I point out the key, if you're going to fill out these forms, is actually read in the lower right-hand corner the filing instructions. They're not very long, but they're clear as to how you fill out this form and where you submit it and the deadline for getting it submitted. You submit it to the supervisor of elections. Typically, you'll receive these forms in the mail from the supervisor. And once they're completed before the deadline, they go back to the supervisor of elections. I recommend, and I can't remember if I did it in my presentation here, but I do recommend providing a copy of your Form 1 to the records clerk, because these forms are public records and there is a chance that some member of the public could request a copy of a given board member's financial disclosure forms. So it's easy to respond to that type of public records request if the records custodian has a copy of what you submit on an annual basis. You can go to the next slide. So these are, from my experience, some of the most common mistakes with respect to completing the financial disclosure forms. Not checking the actual disclosure period that you're making the reporting for. In other, you've missed the time period. Not reading the instructions. Again, that's kind of the succinct place to help you if you've got any questions completing the form. And to the extent you have a vacation property up north or another residence that you spend time in during the year, not listing that in your assets on your Form 1. Next slide. So this is the Form 1F, and again, the F means it's final. It's your last financial disclosure. You submit these to the supervisor of elections within 60 days after leaving your office, and the form would cover a disclosure between January 1st of that particular year, that's your final year in office, and the day that you left the office. And here's a copy of the Form 1F. And these forms, by the way, they are available at the Commission on Ethics website. That's where I procure them to plug them into this PowerPoint. Again, with the Form 1F, the data that goes into the form is very similar to the Form 1. It's just the time frame again is only that part of the calendar year of your final year before you leave office. And again, I point out the filing instructions in the lower right. They're very helpful and explain the timing aspects of the Form 1F. Next slide is what's the Commission on Ethics has a separate Form 1X. It is also a financial disclosure form, and this is used if you have to amend your original Form 1. If you forgot about your ownership interest in a piece of real estate that you own with your brother, for example, but you forgot to disclose that in your original Form 1, you can amend your Form 1 at any time by completing the Form 1X.
Chris?
Yeah.
Preston Oliver here. A real quick question. This came up when I had to fill mine out. I've got timeshares in 2 different states that I can use a week each time. Is that considered personal property? I only have a week each year if I can use them.
Your interest in that real estate, you have title to a fractional ownership, correct?
That's right.
Yeah, so that would be deemed an asset even if you don't use it.
Thank you.
Okay, the next financial disclosure form that is required by the Commission on Ethics is a Form 9, which is your gift disclosure form. And stated succinctly as it shows here in the slide, all gifts received by a supervisor, which the supervisor believes to be in excess of $100, must be disclosed on a quarterly basis by submitting and completing a Form 9. The Form 9 is different than the Form 1s because the Form 9 goes to the Commission on Ethics. You have to mail it up to Tallahassee as opposed to sending it to the supervisor of elections. And that's explained in the filing instructions, again, down at the bottom of the Form 9. It tells you that these gift disclosures, again, it's for gifts over $100, they have to be disclosed to the Commission on Ethics. Okay, so the next slide, I guess I did have this in here. Submission to the Ethics Commission or the supervisor of any of these forms are public records. So my recommendation is you supply copies of your financial disclosure forms to the records custodian. That's Marie, right? Yes. So that she has them in the event that there is a public records request for your financial disclosures. So, and I'm repeating myself, but if there is a public records request for any of your disclosure forms, they are public records, so they need to be produced in accordance with Chapter 119 of the Florida statutes. Next slide. So this is just kind of a summary of the filing deadlines for financial disclosure forms. The Form 1 needs to be filed by July 1st of any given year, but as I mentioned before, within 30 days of when you first assume your role as a supervisor. So for those that are new on the board, that 30-day period may have already, it depends on when you were sworn in, but that may be coming up or may have already passed. So Form 1s should be completed and submitted to the supervisor of election for any new supervisors. There is a grace period by statute for those that missed the July 1st filing deadline. That goes up into September 1st of a given year. After September 1st, you start running into a civil penalty for missing that September 1st deadline. Next slide. So this is the deadline. It's $25. This is the penalty. I mean, it's $25 for each day after September 1st, up to a statutory maximum of $1,500. And if you fail to file your financial disclosures, you can be subject to a complaint by any member of the public. And sometimes that is the way that the Commission on Ethics is triggered to open a case file, an investigation against a public official who has failed to file their financial disclosure forms in accordance with the deadlines set by statute. So in addition to the monetary penalty, if you file after the grace period, if you file after September 1st, you can see there's potentially more harsh penalties that can be imposed by the Commission on Ethics, including removal of office, a public censure, reprimand, or disqualification from being on a future ballot. Next slide. And I mentioned this at the front end of my remarks. There are no criminal penalties for violations of the Code of Ethics, but there are potentially civil administrative fines which can be imposed for violations of either the prohibitions that I discussed or a failure to make the disclosures that we've just went through. In addition to civil penalties, you can see all the other things. This is right out of the statute. Removal or suspension from office, a public censure, a reprimand, a demotion, a reduction in your salary. And if you've received a financial benefit in violation of prohibited conduct, then you can be required to make restitution for any financial gain you have obtained in violation of the Code of Ethics, and or a civil penalty that can be imposed by the Commission on Ethics up to $10,000. Next slide. If you fail outright to fail your annual financial disclosures, this is kind of redundant to what I said before. There's a $25 per day fine that can be imposed, and then that penalty can run all the way up to $1,500. Obviously, my point being, and being repetitive about it, is make sure that your financial disclosure forms are filed annually, and do your level best to get those forms filed by the stated deadline of July 1st, but in no instance, don't wait beyond September 1st because you're subject to the penalties. So that's the nutshell version of the Code of Ethics. Are there any questions?
None here.
Chris, a quick question. In the corporate world, one director can disclose a conflict and the other directors can approve that board members continued participation in the issue, including voting. If I understood what you said correctly, the CDD supervisors do not have that option.
You're correct. That those conflicts, if you have a recognized conflict of interest, that is by statute prohibited from you voting on that. But it happens, and if it does happen, when you are when you recognize the conflict at the first meeting that you're back in session with your board, that's when you can disclose the conflict if you don't realize it prior to taking the vote. But yeah, it's a statutory prohibition. It's not like in the realm of corporate governance, whereas, as you astutely point out, the other members of the board can ostensibly waive the conflict and let you go forward with your vote. It's not like that as a public official.
Okay. And I assume financial benefit doesn't include ongoing operations. Repairing a pothole in front of my street, requesting the operations staff to fix a pothole doesn't qualify as inappropriate financial interest.
In my opinion, I would say no, because the right-of-way, even though the pothole is right in front of your home, the right-of-way is for the benefit of everybody in the district, and frankly, everybody in the public has access to those public rights-of-way. So that would not, in my view, be a prohibited conflict if you had notified staff that there's a pothole repair, it just happens to be in front of your house.
Chris, this is Preston Olinger again.
Yes.
I have in my own mind, I've got a conflict I'd like between you and Mr. Cohen to resolve. In his presentation, I'm not allowed to accept any gifts of any value, but I have to report anything that I accept that's over $100. How does those two compute?
One is to convey to the public information about gifts that you are accepting. My recommendation is don't accept gifts if those gifts would have any bearing on how you were to act or vote in a matter that comes before the board, because that would be perceived, and I think rightly so, would be a violation of accepting gifts which may influence your duties or your role in taking action on a matter that the board is engaging in. So, but if you do take a gift and you don't believe it's going to be something that's going to affect your decision making, if the gift is valued in excess of $100, you still have to report it, even if it has nothing to do with your actions with voting.
Thank you. That clarifies it in my mind, because I was under the impression I couldn't take any gifts. Not that anybody's offered me any, but if they want to take me to dinner or something.
If you believe that they may influence your duties as a member of the board or affect how you would vote on a matter that the board is taking up, then that's prohibited.
I think they might be concerned about getting Lori's cookies and goodies that she bakes, right, Preston?
No, that had not come into mind, but you brought that up.
Since I've had Lori's cookies, I think the legislature is working on a carve out for the Lori's cookie exception to gifts.
Right.
Anything else?
Excellent.
Okay, well, we'll go back to, this is the portion of the presentation that goes more into the IDA information. I know some of you board members that have been with us for years and years, you know, a lot of this information will probably be like the back of your hand, you know it. So feel free to log off, or feel free to stay and talk about IDA and our meetings and just some of the jurisdictions that we have.
Annie, your speaker again is very low, muffled.
Let me try calling a different way. Hold on just a moment.
Okay, can you hear me now? Sorry about that.
Just lost 6 decibels of my hearing.
I think I'm gonna go home after this. I've had my luck on this meeting. Okay, so we'll go over more of the IDA information for the presentation. I think most of you do realize where the boundaries of Lakewood Ranch in general are, all the way up to 64, down halfway to Fruitville. So that covers the whole pink area, the stewardship district. And then our phase 1 area, which is already governed by the residents, is located here in the gray and white area. So we're about 1/3 of the area for the whole of Lakewood Ranch. District 1 being Summerfield Riverwalk, District 2 being Country Club Edgewater, and it is Country Club South. That's kind of a technical way of describing it. District 5 is Country Club North. District 6 is Country Club West, although a lot of Lakewood Ranch residents do call Country Club West the entire Country Club area, because there is Country Club East over here. That can get confusing, but Country Club West Homeowners Association is District 6, and then District 4 is Greenbrook area. So that gives you an idea of our jurisdictional boundaries. For some of you, the newer board members, you may or may not have known kind of where the boundaries for the different country clubs are, or Summerfield Riverwalk, so that gives you an idea on that. Being a special district, we are governed by the Chapter 190 in the Florida statutes. It gives us our general powers and what restrictions we have, and that we are a special purpose government, so we are limited to the actions that we can take. Ours at Lakewood Ranch are pretty much just the infrastructure. As if we were a town is a general purpose government, or the county is a general purpose government. They can make rules and regulations for the general good of the community, whereas ours is just for the special infrastructure in our case. Some of the benefits of being a CDD and why probably SMR looked at it in the beginning is you can save money by doing tax exempt bonds for putting together all the infrastructure in the beginning. It's a way to maintain the look and feel of the community and to gain accountability for utilizing the public resources. And you are governed by a board of electors yourselves who are residents and have the good of the community in mind. One of the most confusing things I think for residents is what the CDD has as far as their jurisdiction and what the AHOA has. One of the easiest ways I usually describe it is the CDDs are, for the most part, all the common areas, and the HOAs really govern what you're doing and what happens inside your own personal property boundaries. The only exception to that is maintenance-free neighborhoods that do, if they have a neighborhood pool, they have kind of some common areas of their own that they regulate. But the deed restrictions and architectural and landscape modifications are under the HOA, whereas the CDD is more of the irrigation and landscaping in those common areas and the right-of-ways of the streets. We were going to spend a little time over the laptop training. We'll do this at our next meeting. We're moving from tablets to laptops. I brought this up at many of your meetings this last month. One of the reasons we went from the tablets is for the same price we could get the small laptops that have the touchable screen, and that way they can be purposed for other issues if we need staff that need to remote. What we realized during the COVID time was we didn't have enough laptops to make it available, although most of our employees did utilize their own laptops and desktops from home. But we'll go into that a little bit more at your next meeting. We are going to be showing you the next version of Civic Clerk. It's Civic Clerk 8, and Marie will go over that. We will still have the PDF version, but we're going to try and talk you into going to more of the online version where you sign in, log in, and your password. There's some flexibility with it, with putting in your own notes for reference during the meeting for you to look at. Our board meeting procedures, most of you have already been in the board meetings, and luckily for us, most of the newer board members have actually sat in many of our meetings, both HOAs and district meetings. We have the chairman, board officers, and then the executive director. I usually facilitate the meeting in coordination with the chairman, and each board has policies on their own public comments. As Andy spoke about earlier, though, we typically at the very beginning of the meeting, we have audience comments where a resident or any audience could bring up any question, whether it's on the agenda or not, covered on the agenda or not. Typically, our board meetings are very not real strict as far as when you go to a county meeting, you're not going to be from the audience speaking to the board or the county commission. They have it, you go during the audience comment time only. We're a little more relaxed with most of our board meetings. We tend to, because we don't have a lot of audience, and sometimes that audience is people that come all the time, so they have questions on an agenda item as the board's discussing it. And typically the board is very good about just letting them ask their questions at the time that it comes up for them. That isn't how it has to be. The chairman can change that, but like I said, most of our board meetings have been a little more relaxed and a little less formal. And we have our monthly board workshops and regular board meetings. I went ahead and put, it's generally the third week of the month. We've been moving that around a little bit because of some of the boards. District 4 does both of their meetings on Wednesday. Now District 5 has decided to go ahead and move to a Tuesday afternoon meeting for both their board workshop and regular meeting. And then District 6 has moved their board workshops and board meetings to the Thursday. But it's generally the third Thursday of the month is the week that we call Board Week. So the employees with the CDD under the IDA is who hires and keeps the employees, and we manage the day-to-day business, the compliance of all the government regulations. We watch over the finances of it and perform the administrative services and customer service. And then we communicate between the board and town hall staff and all the consultants that we use for different projects, and of course the residents.
Betty,
Yes? Oh, sorry, Mr. Swiden.
oh, I'm sorry. I thought I muted.
That's okay. We have, on our administrative team, we have myself, the executive director, we have the executive clerk, HR generalist, which is Ms. Marie, the IT specialist, Mike Knauer, and then our purchasing manager, Anna Owen, servicing you with different administrative functions. Then on the operations, everybody knows operations with Paul and his team overseeing the landscaping and all the day-to-day activities of all the infrastructure that we have, including the guardhouses, gates, signage, all of our street lights. Very important items and very visual. Then our finance team sees over all the financial functions, our budget, our payroll, all of the accounts receivable and payable, our monthly reporting, and as will happen this week, our audits. So we have the treasurers coming in on Thursday, and you'll hear about the audits. If you're not the treasurer, you'll hear about them at your next meeting. Our annual budget process is starting up. Each one of the boards, Steve is very good about going through your schedule. We start up in March, and the board workshops are March through May. Sometimes the boards get to the point where they cancel the May meeting if they're pretty settled on what the budget is. But come May for the IDA, that's when the preliminary budget actually gets approved. And then for the districts, they're always a month behind because the budget information that goes into the IDA budget then trickles to the districts, and so they are a month behind in approving their budget in case there were any changes to the IDA. Then in late August is when that approved budget gets sent out as a heads up to all of the residents and or all the property owners for mailing of the trim notice. It's truth in millage, and gives them an idea of what may be coming in their next tax bill. Then the final adoption is for the budget is in July for the IDA, and then the districts for in August. And actually, once they approve the budget, you can make additional changes to the budget. However, you cannot increase the budget after that point. You can only decrease it. We can't, because that the public is notified or the property owners are notified what the maximum can be through their trim notice. And so at final adoption, you can always decrease, but you cannot increase. And then the tax bills go to the property owners in Manatee County around October, and they can start paying that bill early to a little savings or later at the full amount. I believe that is our last slide. Just kind of a quick overview of the IDA and those actions we take. I don't know if there's any questions related to that. Everybody fall asleep on me?
Still here.
No questions.
It's pretty straightforward mostly for that part. I think the biggest part that residents have issues with is who's in charge of the district or the HOA. That's where the lines get blurred a lot for the residents. And we do have the website and Facebook on here. We do have a Facebook page, and with the sunshine that Andy had talked about earlier, you know, we can put out on our Facebook page lots of information, and we do try to put information out there. For the website itself, we do still have the www.lakewoodranchgov.org, and it does take you straight to our homepage. You can also find your way through to it if you go to mylwr.com, but we do still have the URL, so that's where we try to send the residents so that they land on our homepage. So are there any other questions? I think we still have Scott and Andy and Chris with us. If there's anything you thought of as they finished up their presentations.
I have none.
Neither do I. I want to thank all of you, all four of you. As usual, interesting and always something new to learn.
I agree with
Andy?
Alan, and no questions.
Andy, I think we missed your tap dance that Annie promised us.
We had enough excitement today.
This is
We
true.
did, and what I will do is I will melt the two videos together, and I will put those up. I know some of the board members were unable to come, and they did want to watch it at their leisure, so I'll send a link out to it for all of you, and that way, if you'd like to look at it, I will cut out the awful parts. Thank you so much, everyone, for coming. And if you think of any questions, throw them to me, and I'll make sure I get the correct answers from one of our attorneys.
Thank you.
Thank you.
Appreciate
Thanks.
you.
Thank you.
Good job.
Everyone.
Good night.
Bye-bye.
Thank you.
Bye.
Bye-bye.